State of Wisconsin versus Kevin Lychwick, 24 CF 1881. Appearances, please.
The state appears by Chelsea Thompson and Dan Tombosco. Also at council table is Detective Ben Stern. Good morning.
Good morning. Mr. Lychwick, good morning, sir.
Good morning. Nothing, Your Honor. I'm not well. I need to lay down.
Okay.
I protest these proceedings. I'm being railroaded. I am not prepared to defend myself in this matter.
Mr. Lychwick, we'll get to that in just one moment. Attorney Thompson.
You have hamstringed me every attempt I've made to defend myself. You've denied me my rights of the disposal of tampered evidence and the dismissal of this case. It should never have come this far.
Mr. Lychwick,
I am not feeling well today.
Mr. Lychwick,
you have dragged me here and brutalized me. Look at this. Look what they did to me. Offered no resistance. They dragged me out of my bed. I question your rationality, sir.
Mr. Lychwick, I will let you be heard, but I want to warn you first that if you are speaking out of turn or speaking disruptively or yelling or otherwise causing a disturbance, I may have to remove you from the courtroom. I will let you be heard. I'll let you make a record. Now is not the time to do that, though, okay? Attorney Thompson, is the state in victim rights compliance?
Yes, we are.
All right, we're here for day 2 of the trial. It's now 9:10 a.m. We were scheduled to begin at 8:30 a.m. We got off to a little bit of a late start. Earlier, the court was advised by my deputies that Mr. Lychwick was still remaining in his cell. He was not dressed, and he was refusing to come to court. I had my deputies check with the jail staff to see whether Mr. Lychwick needed more time, whether he was going to voluntarily come up to court, or what the situation was. So we gave Mr. Lychwick about another 35 minutes or so while we explored some other options of how he could be produced for this trial if necessary. So Mr. Lychwick, what would you like to say about your condition today and your ability to proceed to trial?
Well, thank you for letting me finally speak, Your Honor. Again, I reiterate what I first said when I entered here. I am not well today. I need to lay down and rest.
Why is that?
That is the utmost, that is the primary topic right now.
Why do you feel that you need to lay down and rest?
Because I'm sick. For one thing, I have a tear in my belly that needs to be repaired. And I refuse to take responsibility for the delays in the length of these proceedings because I needed medical attention, and you're saying I put it off. I did not. I did not receive the proper consultation. I wasn't even allowed to consult with another doctor before I had the last procedure done that I needed. And I have not received all the surgeries that I need. I again reiterate, I have a tear in my belly that might be part of the cause. I am exhausted. How would you like to sleep for 18 months, Your Honor, a concrete slab, being starved, tortured with lights on you, 24 hours a day, guards harassing you when you're on the toilet, can't even shower in peace or sleep in peace. I can't take this anymore.
Okay, Mr. Lychwick, you've made your record previously when the court has heard your concerns about your medical condition. We've taken testimony previously from the jail administrator. We've heard evidence from your treating physician. And the court has already made rulings about your condition leading up to the case, the previous delays in the case, and the readiness for trial this week. So that matter has already been settled. What I'm concerned about is your present condition today and why you think you have an inability to continue today, this morning.
You're being harassing, Your Honor. I just told you you're making repeat myself. That's harassing. I reiterate. I am exhausted, and I am not well, and I'm nauseous. I have a rip in my belly. What more do you want me to say, Your Honor?
Okay.
I don't mean to raise my voice. I am exasperated. I feel that I am not speaking to somebody who's rational at this point. I don't think you can. You're hearing what you want to hear. So at this point, you're trying to make a fool out of me on top of it. I refuse to be part of this. You're railroading me, I say again. My constitutional rights and my Eighth Amendment rights, for one, under the Constitution, are being violated. My human rights.
Mr. Lychwick, I'm going to give you a few different, I understand. I'm going to give you a few different options. I'll let you know, though, that every one of those options leads to the same conclusion and endpoint, which is that the trial is going to continue today and will continue this week. So here are the options that I'm going to present to you. Number one, we can give you a little bit more time this morning to compose yourself, to do what you need to do, to get dressed into your suit that you were in yesterday, because I'll make a record that today you are in the jail orange and we produced you in a wheelchair. You've been handcuffed for the safety of everyone because we don't know what condition you're in or what your attitude was going to be. So I can give you more time to compose yourself, to get ready for trial this morning, maybe until about 10 a.m. That's another 45 minutes. You can freshen up. You can get dressed into your street clothes and resume the trial in the chair at counsel table with your legs secured to the floor like you were yesterday. So there's no outward sign that you're in custody. That's option number one. Option number two, if you're not going to refuse, or if you're going to refuse option number one, is we can keep you in the courtroom as you are now. You're going to be obviously in jail orange. You're obviously going to be in a wheelchair, and we can, I'll defer to my deputies, but we can likely make arrangements for just the leg shackle to be used. But then you are going to be viewed as in custody by the jury. We can give them a cautionary instruction to make sure that that's not used against you in any way. But again, as I said yesterday, efforts were undertaken to make sure the jury was aware that you are not aware that you are in custody. So that would certainly change today. That's option number two. Option number three is if you are going to be disruptive in court today, I may have you produced in one of the holding cells in the bullpen here. It's a white room. It doesn't have any outward signs, at least while it's displayed on video, that you would be in custody. I would give you the option to be in that room dressed in civilian clothing, or you could appear in your jail orange there. You would have all your materials there. We could still make arrangements for you to have access to standby counsel. If you want standby counsel to consult with you on anything, we could put you in a breakout room over video for that. And then you would participate in this trial by video. So you would be displayed on the video screens. The jury would see you on their screens. We would see and hear you. You could still make objections. You could still interject. You could still cross-examine witnesses just like you would if you were in the courtroom. That's option number three. Option number four is the most drastic option, really, Mr. Lychwick, and that is that if you refuse to participate and conduct yourself accordingly, I may have to have you removed from the courtroom and just not produced at all for your trial, in which case there is a way that the court could make findings that the trial would have to proceed with you in absentia. The reason why that is a very drastic remedy here and a drastic option, Mr. Lychwick, is because you are representing yourself. You would not have the benefit of an attorney continuing to represent your interests at trial if you are not here in person. You have standby counsel. I likely would not have Attorney Galaviz suddenly become your advocate counsel and advocate for you because you specifically wanted Attorney Galaviz to withdraw. You wanted to represent yourself. I took the colloquy of your waiver. I find that you are still competent to represent yourself. You asked good questions yesterday. You raised objections yesterday. You gave an opening statement. You're clearly qualified and competent to represent yourself. So I would not have Attorney Galaviz step in and represent your interests, which means that there just would be no presence by the defense. I don't want to exercise that option. That would be only in the event that you're unable to comport yourself and abide by my rules and abide by decorum in the court. So those are essentially your four options, Mr. Lychwick. Do you want time today until about 10 o'clock to get into civilian clothes, freshen up, get your materials up here into court, and continue with the trial?
This is not rational. You haven't listened to a word I said, Your Honor. With all due respect to the court and the people of Waukesha County, I am not up to being here today. I need to lay down and rest. I am not well. That's all I can say. I've said it before. I've said it twice since I came in here. I've told your deputies and the jail staff at least 4 times on the way up here, and the fact that they were hurting me. So I'm not being heard. You're refusing to listen to me. What more can I do?
Mr. Lychwick, I'll ask you again. Do you want time this morning to get into civilian clothes, to freshen up, to meaningfully participate in your case this morning in court like you were yesterday? Are you going to answer?
I've tried to answer. You won't listen to me.
Okay. Well, Mr. Lychwick, well, the trial is going to proceed whether or not you are actively participating or whether you're protesting or refusing to participate. So now the question is, do we have you stay there in your wheelchair, secure, in jail clothes, so that at least you're in the courtroom and can choose to participate when and if you feel like participating? Do you want to remain in the courtroom, or would you rather be in the holding cell by video?
This is not rational. I've answered your question already 3 times. I don't know what else to say. I need to lay down, Your Honor. I need to go back to my cell and lay down. That's all I can tell you. When I feel better, I'll let you know. That's all that's the final word here. I don't know what else to do.
Well, that's why I'm offering, Mr. Lychwick, to delay this a little bit more this morning, to give you an opportunity to freshen up, to do what you need to do and get into civilian clothes, and then come back in the courtroom and participate. But we can't put the trial off today just because you don't feel well. I'm willing to give you more time this morning, but it's going to resume this morning, probably about 10 a.m. We'll bring the jury in. They've been waiting patiently for 50 minutes now. I can have them wait a little bit longer. Is that what you want to do, Mr. Lychwick?
I told you I'm not well. I don't think an hour is going to make any difference, Your Honor. With all due respect to your title, I don't know how to answer you anymore.
Okay. Mr. Lychwick, I want to be very clear. This trial is proceeding whether or not you participate. So I'm giving you the option. Either you're going to be here in person, you're going to be in the holding cell, or if you're, right now you're not being disruptive. So I'm not going to force you to go back to your cell and just continue the trial without you here. But if you are just going to sit there, that's fine. The jury's going to understand that you're in jail orange. I'll give them a cautionary instruction that they're not to consider that in any way. If you exhibit disruptive behavior, though, if you yell, raise your voice, speak out of turn, it may become necessary to remove you from the courtroom. Do you understand that, Mr. Lychwick?
I understand perfectly well.
Do you have your trial materials with you right now?
No, because I am not well. I do not have my glasses with me. I am not well. I am not up. I am done answering these questions. This is insane. I have answered your questions. I have been polite and answered your questions, even though I am under extreme duress and in pain and not well and nauseous and tired beyond belief. I don't know what more to tell you. You refuse to listen to me. I hope this is being put on the record.
We're on the record,
Your
Mr.
stenographer
Lychwick.
recording all this, Your Honor?
My court reporter is taking down everything that's been said so far. All right, Mr. Lychwick, what I'm going to do is have the jail staff produce your trial materials.
No,
your glasses.
I do not want that taken out of my cell, Your Honor. Please, no. I am not up to looking at it. I am not up. I need to lay down. It's going to get lost and disheveled like yesterday. Your deputies dropped it all over the floor. It took me hours to put it back together again.
Mr. Lychwick, either they gather your materials and bring them up to you, or we're proceeding without your materials in front of you.
I don't want them brought up here. And I'm telling you again, Your Honor, I am not up to being here right now. I need to lay down.
Mr. Lychwick, yesterday I saw you taking a lot of notes during trial. You were taking notes after hearing certain answers. You were taking notes when the court was talking to you and citing some cases. So I know that you've been taking notes during the trial. I want you to have those notes. I want you to have your materials that you prepared.
I won't, Your Honor, I won't be able to use them. I don't know what to tell you. I am not well. I don't need that. If you bring them here, they're going to get lost and spilled all over the floor again and manhandled. Just leave them alone, Your Honor. When I feel better, I'm repeating myself again. You're making a fool out of me, Your Honor. I will let you know when I'm feeling well. That's all I can tell you.
Mr. Lychwick, then I am going to bring the jury in, and we're going to resume this trial. I'll give you one more opportunity to have about a 45-minute recess, get yourself into street clothes, get your materials, get your glasses, and prepare yourself for trial. Do you want that time, or should we bring the jury in?
I'm telling you, Your Honor, I am not ready. I am not well. I don't know what else to tell you.
All right. Attorney Thompson, does the state have any position at this point?
No, I think that the options the court laid out are the available options. Mr. Lychwick has not really made a decision. He's non-responsive to the court, so I think we proceed with the trial. The state has witnesses here, and we are prepared to proceed.
Okay. Mr. Lychwick, one more time, I just want to roadmap here where this case could go, depending on your behavior as we go forward. As I said, I'm going to bring the jury in. I will give them a cautionary instruction that they are not to consider your current clothing, your current restraints. On that note, deputies, with courtroom security in mind, can Mr. Lychwick be secured just with the ankle harness?
We could do that. Remove everyone first.
Okay. I just wanted to make sure that's an option. All right. So Mr. Lychwick will make sure that your hands are free and that you are secured by the ankle restraint, but you will still be in jail clothes. I'll tell the jury that they are not to consider anything about your appearance today and infer anything from that and not hold that against you. And we'll proceed with the trial. If at any point you want to stop and get your materials, I can allow you to do that, but they'll be brought up to you. We're not going to have you go down to your cell at this point and gather those materials up. They will be brought up for you to assist you in your defense. If you become disruptive or interject or talk out of turn or speak loudly or continue to raise objections on things that the court has already ruled on, I may have to remove you from the courtroom and place you in the holding cell there. By that step, you would still be produced by video. You would still have an audio feed. We would still be able to hear you. That would give you an opportunity to still participate, but it would also give me an opportunity to mute your microphone if you are continuing to be disruptive. I would continue to give you warnings about your disruptive conduct, and if the disruptive conduct continued to the point where it was impossible to continue, then I would have to remove you and place you back in your cell. And at that point, the trial would continue with you in absentia. And I would not be appointing an attorney to represent you because you are proceeding pro se and you wanted your last attorney to withdraw. So, Mr. Lychwick, that's the potential outcomes here as we go forward. Otherwise, if at any point you want to get your materials and get into civilian clothes, we can talk about that. Understood?
No, it's not understood, Your Honor. I don't understand a thing you're saying because it doesn't make any sense. I told you what I told you. Refuse to listen to me.
All right. In order to change the defendant's restraints, we are going to have to clear the courtroom again. So I'm going to ask all of the public to exit the courtroom so that the deputies can take care of that, and then we will reopen the courtroom and proceed.